Hi guys, it's Houston immigration attorney Pegah Rahgozar. Welcome back for another episode of Wednesday Wisdom with Pegah. A little bit about the Rahgozar law firm. Our principal office is located in Houston, Texas, but we do take cases from across the U.S. and outside of the U.S. advising on U.S. immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as other topics and more about me on our website at www.rahgozarlaw.com. Today's topic is about petitioning for your fiancé and obtaining a K-1 visa. But before I dive in, as usual, I'd like to inform you that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Every case is different, and immigration is a fact-intensive area of the law, so be sure to seek proper legal advice from an experienced immigration attorney before filing any sort of application or petition with USCIS or with any immigration agency. So you have a special someone outside of the US and you wish to apply for them to come to the US so you can marry them. Well, the process is usually through the K-1 fiancé route. The K-1 fiancé visa is for the foreign fiancé of a U.S. citizen and allows them to enter the U.S. and marry his or her U.S. citizen sponsor within 90 days and then pursue permanent residency. What are the basic eligibilities for filing for a fiancé visa? Well, first of all, you must be a U.S. citizen. Unfortunately, permanent residents do not have this privilege. It's only a right given to U.S. citizens. Number two, you and your fiancé must show that you intend to marry each other within 90 days of your fiancé's entry into the U.S. Number three, you and your fiancé must be legally able to marry each other. What that means is that you're not married to someone else currently, and all past marriages have been resolved through either death, divorce, or annulment. Number four, you as the U.S. citizen must be able to show sufficient income to financially support your fiancé. And last but not least, number five, you and your fiancé must have met each other in person in the last 2 years before filing your fiancé petition. This meeting must have occurred before the petition is filed. You cannot file the petition first and during the pendency of the case go and meet your fiancé. Those requirements have to have been met prior to filing. Otherwise, your case will get denied. There are two exceptions to the 2-year meeting requirement, and it could either be based on one, resulting in extreme hardship to the U.S. petitioner, usually due to a disability, or the meeting would violate strict and long-established customs of the beneficiary's foreign culture and social practice. So this is usually common where marriages are traditionally arranged and the bride and groom are not allowed to see each other prior to their wedding day. If you have any questions about whether you qualify for a fiancé visa or how to file for a fiancé visa, then please contact our office at 832-792-3636. Make an appointment and we can discuss your case. If your fiancé has children, those children can also receive a visa as a K-2 visa holder, and they're able to accompany the primary K-1 visa holder into the U.S. The children only have to be listed initially on the fiancé petition. They don't need their own separate petitions. However, once you get to the NVC stage, which I'll discuss shortly, they'll each apply for their own separate visa applications and pay their visa fees. So how long does the petition approval generally take, and what happens after USCIS approves the fiancé petition? The entire process from filing with USCIS until you get your visa interview generally takes anywhere from 7 to 9 months on average, but of course this can vary depending on the factors of your case, which can make the process either longer or shorter. However, once USCIS does approve your fiancé petition, then the case goes to the National Visa Center, otherwise known as NVC, and they're ready to begin the consular processing stage of your case. This is where you're going to provide additional documentation regarding the beneficiary, so things like police clearances. You're going to also provide the affidavit of support, along with filling out the non-immigrant visa application, paying visa fees, and certain other documents as well. Then once everything is complete, the National Visa Center, or NVC, will proceed with scheduling an interview with the local consulate in your fiance's home country. One thing to note, though, is that the approved fiancé petition is only valid for 4 months, but if it is taking the consulate a longer time to process the visa and issue the visa, then they themselves can extend the validity period of the petition for additional months. So what happens after you're approved your visa and you receive your K-1 visa? Well, the consulate will issue your K-1 visa in your valid passport that you'll be using to travel to the U.S. The consular officer will also provide you a sealed packet with certain documents that you must present to the customs upon entering the U.S. You're only allowed one single entry on your K-1 visa, and the validity period for the K-1 visa, once it's issued, is valid for up to 6 months. So you must travel to the U.S. within that time frame. What happens if you're denied your K-1 visa? Well, if you're denied, the consular officer will likely tell you under what grounds they're denying you. Some of the common issues can be related to maybe something in your medical exam that prevents you from being eligible for the visa. It could be past crimes, previous visa violations or overstays, lying on any immigration applications or petitions, or submitting fraudulent documentations. Also, there can be issues if your U.S. citizen fiancé has filed for past fiancé petitions. Of course, depending on what the issue is, the consular officer will let you know whether you qualify for a waiver or not. If the consulate has found you ineligible for a fiancé visa and has denied your case, please contact our office at 832-792-3636. Make an appointment so we can discuss what the issues of your case are. So let's say you are approved your K-1 visa and you do enter. What do you do after you enter the U.S.? Well, once you enter, your visa, as mentioned, is only valid for 90 days. It does expire at the end of the 90th day. During those 90 days, you must marry your fiancé who petitioned for you, and then you must proceed to apply for your permanent residency to obtain your green card. While your case is pending, you'll be allowed to receive work authorization and also a travel document if you have applied for it. And with the work permit, you can also apply to get a social security card and a driver's license. 3 important notes I will make, particularly regarding the K-1 visas. These are very special and strict visas. Unlike your normal tourist visas, these carry problems if you don't properly follow the instructions you're given and you don't timely abide by them. So one issue that I'd like to bring up is if you fail to marry and apply for your green card within 90 days, you risk falling out of status and being subject to deportation. You can't extend the fiancé visa like you can with a tourist visa, and you must timely depart back to your country. Another issue is if you marry timely, but you apply for your green card after the 90 days, then your fiancé has to actually file a marriage-based petition together with a green card application, not just the green card application on its own. So this is if you wait after the 90 days to apply for your green card, but the marriage occurred within the 90 days. And the last note I'll make is that if you fail to marry your fiancé, and this is a big one, who brought you into the U.S., and instead you marry someone else, you will not be eligible to obtain a green card through that marriage to that different person here in the U.S. That's a big one. We've seen that issue happen a lot where they come in with the intent to marry the fiancé that petitioned for them. It doesn't work out for some reason. Then they go start a relationship with somebody else, overstay their visa clearly, don't get married to who petitioned for them, and then they end up marrying that person and think that they qualify to obtain a green card. And they're not. They would then face deportation proceedings and have to find alternative ways to stay in the country because that new spouse pretty much won't be able to apply for your fiancé visa or to apply for a marriage-based case for you. If you guys have any questions related to this topic or other topics, then please contact us at our office at 832-792-3636. Make an appointment to discuss your case. You're also welcome to post comments or questions that are about basic immigration questions or topics that we've discussed on this video as well as any of our other videos, or you may directly message our law firm page on Facebook. That concludes another episode of Wednesday Wisdom with Pegah. Thank you guys, and I'll see you next week for another episode of Wednesday Wisdom. Good night.